Hello friends, my name is Alok Sukla. I am a practicing advocate in the Supreme Court, and today I will discuss the topic judicial process, legal ethics, role of legal profession and ethics, and we will be discussing judicial process, role of legal profession and ethics. First of all, let us understand what is judicial process, and that will start with understanding what is justice. Justice is rule of law. It is absence of arbitrariness. And judicial we can describe something related to administration of justice. The process can be described as a series of acts directed to achieve some ends, and thus the judicial process can be summarized as a series of acts directed to achieve administration of justice. It is often described as a study of is and ought of the law, what the law is and what it ought to be. In a constantly evolving society, the needs of the society requires law to evolve, and this is the very purpose for which we are studying this process, the topic the judicial process. Judicial process is also often described as an antonym of arbitrariness. The Constitution of India has given a mandate to the judiciary to safeguard the interest of the people and to uphold the constitutional values. The principle of separation of power and independence of judiciary, which is enshrined in our constitution, has cast a duty on the judiciary of being constantly evolving to cater to the need of the society, which is constantly evolving. In view of the changing scenario of economic policy, in this respect, the judicial process has evolved through various decisions of the Honorable Supreme Court. I would like to discuss some cases, some landmark cases in this regard. The Maneka Gandhi case, which is one of the finest judgment ever written in any court of law, whereby the Honorable Supreme Court broadened the scope of Article 21 and held the state action must conform to reasonableness and fairness. The Honorable Supreme Court expanded the scope of Article 21 and described the term life not only as a vegetative existence of a human being, but that it includes all the facets and limbs of life with which the life can be enjoyed. Then there are cases, Olga Teles and Bandhuva Mukti Morcha cases, where the Honorable Supreme Court done away with the procedural technicalities and treated the letters written by people, the ordinary people, as petitions and passed directions which has a far reaching effect. The other case, which is a landmine case in this respect, is Rudal Shah case. The Honorable Supreme Court discarded the traditional approach and ignored the technicalities while granting compensation to a person who had been living in the prison for 14 years after serving the maximum punishment for which he was lodged in the prison. Then, who can forget MC Mehta's case? The Honorable Supreme Court held that Article 32 is not merely injunctive but also remedial. This case has opened a new chapter in the history of our judicial process. After the MC Mehta's case, the Honorable Supreme Court has been burdened with number of petitions to protect the environment from degradation, and the Supreme Court, in one of the leading cases, T.N. Godavarman versus Union of India, has been constantly monitoring the natural resources and forest, which has been depleting at a very fast pace due to the inaction on the part of the executive and the legislature. Then there is Visakha's case. The Honorable Supreme Court filled the lacuna in the field of sexual harassment of women at workplaces and framed guidelines This case shows us how the judicial process evolves. The women who have started working in public life, they start going to offices. Earlier there was no law, nothing to protect them from sexual harassment at the workplaces. This need was felt by the Honorable Supreme Court in Visakha's case, and the Honorable Supreme Court came with certain guidelines, and that guidelines has now been followed by and large by all the institute across the nation. Now let us discuss the role of judicial process in a progressive society. In a society which is fastly changing, which is fastly evolving, and where the economic goals are to be achieved in a limited span of time, judicial process plays a very vital role. The International Covenant on Civil and Political Right (ICCPR) entails procedural guarantees in civil and criminal law trials. Article 14 of the International Covenant on Civil and Political Right says that all persons shall be equal before the courts and tribunals. In the determination of any criminal charge against him or his right and obligation in suit of law, everyone shall be entitled to a fair and public hearing by a competent, established and impartial tribunal established by law. Now let us discuss the main topic that we want to discuss with you, because it is a topic which we often ignore, the ethics part of it. Why ethics are important? We will discuss about it. The judicial process, as we all know, comprises of bar and bench. And I would like to quote Justice Thomas, a judge of Australian court, who stated that some standards can be prescribed, but the spirit and the quality of service rendered by a profession depends far more on its observance of ethical standards. Recognizing this approach, our former Chief Justice of the Honorable Supreme Court stated that it would be auspicious approach to say that no one who is not accountable to known standards. And therefore, in view of these discussions, our judiciary recognized the need to lay down certain guidelines for judicial ethics. And in this respect, a conference was held at the Supreme Court, where all the Chief Justices of all the High Courts participated, and a restatement of values of judicial life, which we also know as Code of Conduct 1999, was adopted. It entails that justice should not only be done, but it should be seems to have been done. The judges should act in such a manner, they must conduct themselves in such a manner that the faith of the common people of the society, common man of the society, is affirmed in the judicial process of the country. Judge should not contest any election of any society, association or club. A postulate was made that the close association with member of bar should be eschewed. Here I would pause for a moment and would like to give you an example. Our first Attorney General, Mr. M.C. Setalwad, was visiting the International Court of Justice, and one of the judges was very eager to meet Mr. Setalwad, but Mr. Setalwad refused to meet him and told him that since the matter is going on, it would be inappropriate for him to meet the honorable judge. So these are the high standards which has been presented before us by our predecessors and which we have to follow. The other postulate is that a kin or relative of a judge should not appear before him. We all know that there is bound to be favoritism. If somebody known to me appears before me, and I being the judge, even if I does justice, then it does not seems to have been done, because the other party will always have a grudge that the justice has not been done, that there have been some partiality on my side. The other thing is that no member of his family should be allowed to use his official residence by a judge. Judge should not enter a public debate or express his opinion on political matters. Judge should not give interview to media. He should speak through his judgments. Judge should not hear matters where he or his family members have any interest. Judge should not decide company matters where he holds shares unless this fact is disclosed to the other side and the other side gives a no objection for the judge to continue to hold the proceedings. We have examples in the recent past where the Honorable Supreme Court has given such indications to the other sides and have only proceeded after receiving a no objection from the opposite party. The other postulated that the judge shall not speculate in shares, stocks or life. The judge should not ask for contributions or funds. And it was also held in this conference that these canons are merely illustrative and not exhaustive. Now I would like to quote one judgment of the Honorable Supreme Court. In K. Veeraswamy versus Union of India and others, the Honorable Supreme Court, emphasizing the duty of the judge to maintain high standards of conduct, observed that independence and impartiality and objectivity would be tall claims hollow from within unless the judge are honest to their office, honest to the society and honest to themselves. Thereafter, in 2001, Bangalore Summit was called, wherein judges from different Commonwealth countries participated and laid down certain principles of judicial ethics, which were adopted in 2003 in UNHCR conference at Hague. Here the topic would be incomplete if I will not refer to the beautiful judgment written by our former Chief Justice of Delhi High Court, Justice A.P. Shah, in the case of Secretary General Supreme Court of India versus Subhash Chandra Agrawal. The Honorable Delhi High Court held all person possessing a portion of power ought to be strongly and awfully impressed with the idea that they act in trust and that they are to account for the conduct in that trust. In this case, the Honorable High Court, Delhi High Court, held that the Honorable Chief Justice of India cannot claim immunity from disclosing the assets of the judges of the Honorable Supreme Court. So this is the beauty of our judiciary, that they decide the case against themselves while sitting on the dais. Then the second part of the topic, which is very important from the view of most of the students who are going to practice law, the role of lawyers in judicial process. The legal profession plays an important part in the administration of justice. The lawyers are considered to be the center of the administration of justice. Lawyers are the one who are related to the parties. They listen to the parties and collect all the relevant legal material relating to the case and argue the case in the court, thus helping the judge to arrive at the correct and fair judgment. Here comes in play the professional ethics, the duties of lawyers. The professional ethics may be defined as a code of conduct, written or unwritten, for regulating the behavior of a practicing lawyer towards himself, his client, his adversary, and towards the court. In O.P. Sharma versus High Court of Punjab and Haryana, the Honorable Supreme Court examined the professional conduct and etiquettes of the advocate and held the role and status of lawyers at the beginning of the sovereign and democratic India is accounted as extremely vital in deciding that the nation's administration was to be governed by the rule of law. In this respect, we have Chapter 2, Part 6 in the rule of Bar Council of India rules, which lays down certain duties of the lawyers towards the court. A lawyer must conduct himself with self-respect and dignity, being the officer of the court. A lawyer must be respectful towards the court. He shall not try to influence the decision of the court by any illegal or improper means. He shall use his best efforts to restrain and prevent his client from resorting to sharp or unfair practices. He shall appear in the court in the prescribed uniform. He shall not appear before his relative or kin. He shall not appear in matters he is personally interested. It is very important to know that we cannot appear in matters where we have a personal interest. Like a judge cannot decide a matter in which he has a personal interest, we cannot appear in a matter in which we have a personal interest. Because being the officer of the court, we are bound to follow the very maxim which the judiciary is following. We have to be impartial while we are acting as officer of the court. The other postulate in this regard is an advocate shall not stand as a surety for his client, because once we stand as a surety for our client, we become a party to the litigation. In this respect, I would like to quote certain judgments of the Honorable Supreme Court. In R.D. Saxena versus Balram Prasad Sharma, the Honorable Supreme Court held that the lawyers have a social duty to show the people beacon of light by their conduct and action. In Radha Mohan Lal versus Rajasthan High Court, the Honorable Supreme Court held that advocate touches and asserts the primary value of the freedom of expression. It is a practical manifestation of this principle of freedom of speech. Therefore, the Honorable Supreme Court has gone to the length to postulate that the lawyers aspires and asserts and touches the very primary value of the freedom of expression. I would like to quote one example from our religious text in this matter. We all know the incidents when Hanumana went to Lanka and he was captured by the demons and produced before Ravana. Ravana was of the view to hang him. At the same time, Vibhishan, without any fear or favor, stood up to his defense and gave words of wisdom to Ravana and told him that being a messenger, he is merely conveying the message of his king, and his punishment should be proportionate to his actions only. And therefore, we have a long history of following these traditions of ethics, and the lawyers have been playing a vital role in the development of judicial process. And here I would like to quote one more judgment of the Honorable Supreme Court, Supreme Court Bar Association versus Union of India and another, where the Honorable Supreme Court held that the power of the Supreme Court to punish for contempt of court, though quite wide, is yet limited and cannot be expanded to include the power to determine whether an advocate is guilty of professional misconduct or not. Because if this Honorable Supreme Court decides this fact itself under Article 142, in that case the lawyer will lose the right to appeal, because under Section 35, a lawyer who is found guilty of professional misconduct has a right to appeal to the Honorable Supreme Court. The Honorable Supreme Court held that the power to do complete justice under Article 142 is in a way corrective power which gives preference to equity over law, but it cannot be used to deprive a professional lawyer of the due process contained in the Advocates Act 1961 by suspending his license to practice in a summary manner while dealing with a case of contempt of court. The other judgment is Lalit Mohan Das versus Advocate General Orissa and another, where the Honorable Supreme Court held that a member of the bar undoubtedly owes a duty to his client and must place before the court all that can fairly and reasonably be submitted on behalf of his client. He may even submit that a particular order is not correct and may ask for a review of that order. At the same time, a member of the bar is an officer of the court and owes a duty to the court in which he is appearing. So, the Honorable Supreme Court has time and again laid emphasis on the conduct of lawyers in the courts. Now, we come to the Section 2, that is the duty of the lawyers towards the client. An advocate is bound to accept any brief in the court or tribunal, and he cannot refuse the same unless exceptional circumstances exist for refusing the same. An advocate shall not ordinarily withdraw from engagements without sufficient cause. An advocate should not accept briefs where he has reasons to believe that he may be or he will be a competent witness, and if he is engaged in such a case and it becomes apparent that he is a witness on a material question of fact, he should not continue to appear as an advocate if he can retire without affecting the interest of his client. An advocate shall, at the commencement of his engagement and during the continuance thereof, make all such full and frank disclosures to his client as to his involvement in the case and his connections with the related parties, which are likely to affect his client's judgment. Next, the advocate should fearlessly try to uphold the interest of his client by all fair and reasonable means. and an advocate who is conducting a prosecution is a duty bound. It is very important that an advocate who is conducting a prosecution is duty bound to conduct the prosecution in such a manner that it does not lead to conviction of an innocent person. So, it is a duty of the prosecuting lawyer that he should not conduct the prosecution in such a manner. It is very important, being a student, we must understand that even if we are on the other side of the legal quarrel, where the accused seems to be not guilty of an offence, we must assist the court in arriving in a just and proper conclusion of the entire matter. Next, that our lawyers should not commit a breach of the obligations imposed by section 126 of the Indian Evidence Act. 126 of the Indian Evidence Act says that any information which a lawyer receives from his client, a lawyer should not disclose that information to anybody unless asked by the court itself. The lawyer cannot stipulate for a fee contingent on the result of litigation. This practice is allowed in European countries and America, but in our country this practice has been discouraged. Now, the third part of this, the duty to the opponent. A lawyer owes certain duties to the opponent counsel also, and the opposite party also. An advocate shall not in any way communicate or negotiate upon the subject matter of the controversy with any party represented by an advocate except through that advocate. An advocate shall do his best to carry out all legitimate promises made to the opposite party, even though not reduced in writing or enforceable under the rules of the court. Then there is punishment for misconduct, which is provided in the Bar Council rules. Section 35 of the Advocates Act says and empowers the disciplinary committee of the Bar Council to reprimand the advocate and suspend the advocate from practice for such period as it may deem fit, or remove the name of the advocate from the state roll of advocates. This includes professional as well as other misconducts, and the appeal against this lies to Supreme Court of India. In BP Kumaravelu versus the Bar Council of India, the Honorable Supreme Court has held whether negligence will amount to professional misconduct will depend upon the facts of each case. Gross negligence in the discharge of duties partakes of shades of delinquency and would undoubtedly amount to professional misconduct, but negligence without moral turpitude or delinquency may not amount to professional misconduct. I would like to conclude the topic with this belief that you people would not conclude this as merely a lecture given to you, but will exercise all the ethics and will further the rule of law. Thank you.